Elizabeth Lincecum, Communications Director at the North Carolina Institute for Constitutional Law. Welcome to Cornerstone Commentaries, an opportunity for you to learn more about our state constitution, the people, cases, and history that have made our state what it is today. Today our commentator is former North Carolina Supreme Court Justice Bob Orr, who's also the Executive Director of the Institute.
Every first-year law student is familiar with the landmark U.S. Supreme Court case of Marbury versus Madison. That decision, written by Chief Justice John Marshall in 1803, was the first Supreme Court decision to apply the emerging doctrine of judicial review to a congressional statute. The Court's historic decision set out the role of the judiciary in maintaining constitutional limitations on legislative actions. Today we take for granted the concept of our courts reviewing the constitutionality of government acts and declaring those acts in violation of the Constitution void. While the Marbury decision gets the attention, it was two North Carolinians and one of the earliest decisions by the new North Carolina judiciary that set the stage for Marbury. In November of 1787, the three judges in North Carolina, sitting as our first state Supreme Court, issued the decision in Bayard versus Singleton. The case involved property in New Bern, previously owned by a British loyalist, Samuel Cornell, and confiscated by the state during the Revolutionary War. The property was ultimately sold to a Mr. Singleton, and when Cornell's daughter brought suit claiming title to the property, the stage was set. A state law denied the right to challenge the confiscation and the sale of the land in contravention of the state constitution's guarantee of a jury trial when property rights were at issue. The North Carolina court, long before the Marbury case, held that an act of the legislature in violation of the Constitution could be held invalid by the judiciary. Interestingly, two of the lawyers in the Bayard case may well have influenced the outcome of Marbury. Both James Iredell and Alfred Moore were involved in the Bayard case and were intimately familiar with the holding. Iredell was one of President George Washington's first appointments to the U.S. Supreme Court and served with Marshall. Alfred Moore was appointed to Iredell's seat on the court upon Iredell's death and was a member of the U.S. Supreme Court when Marbury was decided. Iredell and Moore are the only two North Carolinians to serve on our nation's highest court, but their influence was undoubtedly profound. Thanks for watching this Cornerstone Commentary, and remember, the Constitution is the cornerstone of all law.